All right, everyone, hello and welcome to another of Professor Sankoff's Evidence Basic videos. In this video, we're doing something that's a little less basic in the sense that we are looking at some very special issues that arise when you're dealing with character evidence. These are largely confined to criminal trials, and the reason they arise is just because of the special prejudice that is really available when you're talking about an accused person who's on trial for their life, literally. So there are a few things that apply to civil cases, and I'll identify what they are. But it's important to keep in mind that none of what I'm saying here eliminates or is designed to override what I've said in other basics podcasts. It's just a supplement. These supplement issues that arise with character evidence and cause some specific types of problems. So in this video, we're going to look at four things. First, I want to talk about how you prove identity. That's essentially a special problem that arises when you need to prove one issue, one particular issue, that the accused was the person who did this particular crime. Two, I want to look very briefly at multi-count indictments so you can see how similar fact evidence is traditionally adduced. Third, I want to look at the co-accused and the rules governing what happens when you have two accused in a trial. And fourth, I want to look at good character evidence. What if bad character evidence can prove something bad? Can good character evidence prove something good? We'll see. So let's start with the first problem. Identity is a particular issue, and I want to stress to you why it's a particular issue. When you are just trying to prove a character trait, that is one thing. So assume for the moment that Johnny, our particular bad guy, is unquestionably involved in a fight with Bob. There's no dispute about that. The only issue is who started the fight. Now, the propensity evidence can be very useful and very important when we're trying to assess whether or not Johnny attacked Bob. So the fact that Johnny beats up 12 people at that location a day, ridiculous example, but you get it, is useful to dispel the possibility of coincidence that he was defending himself against Bob. Okay? That is standard character evidence use. You are using character to prove a trait. A trait. Identity is different. Identity is a situation where you're trying to prove that some other incidents actually go to prove that this person committed this crime when their identity is in dispute. So for example, I'll give you like a classic example. In fact, I used an example in an earlier video about a glove. Remember I said that there was a situation in which this particular offender tends to drop a glove at the scene. Okay, so the police get to the scene of this robbery and they find a glove. And they have 4 other robberies with a glove. And most importantly, the accused can be connected through visual evidence to 2 or 3 of those other robberies. Okay, but for the 4th, they can't. There's just not a lot of good evidence. Now, there's some circumstantial evidence because you're never going to prove a case on similar fact evidence alone, but let's assume that there's some evidence tying the accused to the 4th robbery, but not enough to convict them on its own. Can you use similar fact evidence to show that they're more likely the person than anyone else? Yes, but I hope you can see that that's a very different type of inference. The inference that you're trying to draw when you're trying to single out every other person in the world has to require a bit more probative value. And the reason for that is simple. Remember, when we go back to Johnny and his character trait, if you're just trying to show that Johnny is more likely to beat people up outside a certain bar, well, that is possible because you're just trying to show that Johnny, this is not a coincidence. Johnny does this a lot. But when you're dealing with identity, what you're trying to do is single out this offender from the rest of the world. And that's a harder thing to do. Historically, and even today, you get discussion of things like striking similarity. We don't look at striking similarity anymore because that test created its own problems. I won't get into all of them, but striking similarity seemed to suggest that there was a particular level of similarity it had to reach, and you could ignore other things like how many times it happened, how closely the accused was connected. We don't use that test. But I wish to stress to you, the courts will always be keen to ensure, number one, that there are links in connection, that the coincidence level is, low, and that the similarity is high. And they will also want to see that the accused can be connected to those similar fact incidents. So I'm just suggesting to you that when you're dealing with identity, because of the nature of the evidence, the test is enforced more stringently. That's the best way to put it. It's not a different test. It's not even a different way of calculating value. But what it is a reminder that before you're going to allow this to be admitted against evidence, to single out the accused from the rest of the human race, that requires a little bit of a higher degree of similarity, because otherwise you can't dispel the coincidence. So this is what's looked at. They're essentially a slightly separate approach. One, is it likely? You have to really look at whether the similar fact evidence and the crimes were committed by the same person. If you can't reach that level, then the evidence is out. Like, it doesn't matter that the accused has committed 7 robberies and you want to prove the 8th. If they're not similar enough, you just can't do it. It's just not enough, because you can't show that it's likely they were committed by the same person. Is there evidence linking the accused to the similar fact evidence? That's really important too, because you can show the gloves all over the place, right? Yes, there's all these gloves at 5 robberies. Well, if you've only got the accused tangentially linked to one of them, like, admitting all 5 is a disaster. Like, you've got to show linkage, and that is the really important thing. And I think you also have to show linkage to the accused to this robbery, or else you're just reasoning by disposition. So that is the key here with identity. It's treated a little differently than other forms of similar fact evidence. Okay, I want to talk very briefly about multi-count indictments, because I just want to remind you that similar fact evidence is normally admitted by saying, okay, the accused is on trial for A, and in the past they did B, C, and D, right? So then you're admitting B, C, and D, and the accused is on trial for A. There's no risk of convicting the accused for B, C, and D, because, like, he's not on trial for that. He's only on trial for A. There is a risk of prejudice in the fact that if you throw enough crap at the accused, it's going to look bad. But that has nothing to do with the fact that he's actually at risk, because he's not. Where this becomes troubling is that it's not always that simple. With multi-count indictments, Johnny will often be charged with beating up 5 people. Like, it's not always true that the Crown will do this, nor is it always possible, but it's not infrequent. The question is whether the Crown is entitled to use each count as similar fact evidence against the other counts, even though you haven't proven beyond a reasonable doubt that they happened. Can they do that? Well, the answer is yes, they can. And the reason for that is because they don't need to prove beyond a reasonable doubt that those other things happened. In fact, they don't need to do that for any similar fact evidence. Evidentiary admissibility, the admission of evidence, whether it goes to the jury at all, is based on a balance of probabilities test. So all you have to do is show in the balance of probabilities that each of these is similar enough to warrant the jury considering them. Think about that. That's your question of law. Should the jury consider these other indictments in deciding whether the accused did this one? So, for example, for crime A, can you use B, C, D, and E to help establish whether A is proven? And the answer is yes. You can even have situations where you have, can you use A, B, and C to prove E, but not D? Yes, that is possible too. Now, let me just stress, this can obviously get a little confusing. So there's a couple of things to keep in mind. One, every use of similar fact evidence must be analyzed. So again, as I said, you may have the accused charged with A, B, C, D, and E. And the Crown may say, well, we want to use each of them against the other. Well, maybe if they're all similar enough, but you may have a situation where A is a little bit dissimilar to B, C, D, and E. So the judge will say, no, in considering A, you have to consider it on the facts alone. In considering B, you can look at C, D, and E to decide if they help you determine whether B is proven beyond a reasonable doubt. Not surprisingly, these can lead to some very complicated trials and some complicated thresholds. But before you wonder as to why we do this, well, we do this because it actually makes a lot of sense. Like, it really does, if you think about it. Like, you shouldn't have an accused tried separately on A, B, C, D, and E. That's not very convenient for justice, nor is it efficient for time resources. Moreover, if you just treat them all individually, like, in theory, the accused might be acquitted of each of them. Because at the end of the day, like, it's only in seeing the whole picture that you can understand what the accused did. And if you treat them all separately, then you're going to have to make applications for similar fact evidence in each case. It's going to be extremely messy. So this is sort of what I call the best of a bad situation. And in many cases, it's the best solution by far. I want to point out, however, the instructions to the jury can get very complex. And as you can imagine, because you have to sort of isolate for the jury how each piece of similar fact evidence can be used. I'm not going to go through those instructions here. This is an evidence basics capsule, but it is complex. That's what I want you to be aware of. Finally, I want to point out that the remedy, if this is going to get really complex, like remember what I said about A can be used for C and B can be used for D and E. Like if it gets that complex, the option for the accused to say, look, I want these severed. It's too problematic and too prejudicial. And if you think about it, imagine a case where A really is isolated. B, C, D, and E are similar, but A has no similarity to B, C, D, and E. I think the accused can make a pretty good case, say, I want to be tried separately on A. Because it's not fair for the jury to hear all this bad character evidence, B, C, D, and E, when you, judge, have already decided that they have no relationship or not a strong enough correlation to A. You can always ask for the judge to sever off cases, and it's very common for this to happen, where there's not enough similarity. So you'll sometimes have an accused who is involved in two trials. One is to deal with the one that's sort of distinct in its fact pattern, and the other to deal with situations that are more similar. Okay, I want to talk about co-accused. This is our third problem involved here. And what do we do with co-accused? Well, this is a little bit strange. I'm not going to lie. Johnny and Fred are both on trial for jointly assaulting Bob. Now, let me just say, the Crown makes an application to admit some bad facts evidence as being similar or whatever, and they lose. They lose, okay? The evidence is inadmissible for the Crown to show that Fred is the type of person who would commit this crime. Okay, so what happens? Now it's the defense lawyer, Johnny's lawyer, who wants to adduce this evidence. Can they do that? Well, the answer is yes, they can. And the reason they can is because admitting defense evidence, as you already hopefully remember, is on a much lower threshold. The Crown has to show that the probative value exceeds the prejudicial effect, and they couldn't do it with this evidence. Too general, wasn't similar enough. But for Johnny, the evidence is admissible unless the prejudicial effect substantially outweighs the probative value. So as a result, Johnny, trying to defend himself, is allowed to attack Fred. It's perfectly logical and perfectly allowable. The question is whether or not it's, what happens when this actually occurs. Sorry, I'm going to go back to this one for a second. There we go. Okay, so can this happen? Yes. Are there rules? Yes, of course. First of all, when the jury gets all the evidence in the case, the first thing they have to be told is, you've heard that Fred beats people up. You've heard that. You can only use that evidence in deciding whether or not Johnny is the responsible perpetrator in this case. That's it. Period. Like, that is it. You cannot use it to decide that Fred's a bad guy and more likely to have done this. It can't be used in that case. I want you to assess that evidence only when you are deciding on Johnny's liability. Because if it comes in that way, it's not fair to use it against Fred in terms of convicting Fred, because that would breach the rules against character evidence. So that's number one. Number two, Johnny doesn't have absolute license to do this. Just because I said that the probative value has to be substantially outweighed, I mean, it doesn't mean you can just say, Fred, you smash puppies around or you do X, Y, and Z. Like, there's got to be enough probative value to get it in. And if the prejudicial effect on Fred is massive, then you can't get it in even if you are Johnny. So that's number 2. And number 3 is there are some impacts to this that I'm going to explore when it comes time to decide whether the accused has put their character in issue. So let's turn to that. So I want to talk about a different type of character evidence to finish off. Now we've got Johnny charged with assaulting Bob, and what happens? That's the question. You've never beaten up anyone in your life, have you? Now, that's an improper question, as we'll see later, but it's a leading question on direct. Forget about that. Let's assume it's a perfectly good question. No, never. Objection. This evidence is prejudicial. So, I mean, is this character evidence? Yes. It's reverse disposition evidence or good character evidence. What you're trying to show is that Johnny is not the type of person who would do this, as opposed to he is the type of person. Opposite sides of a same coin, but a little bit different for reasons I'm going to get into. Is it admissible? The answer is yes. It is admissible, but I'm going to suggest to you that it's admissible in a different sort of way because it's frankly it's not as probative as anything else. The reason is this. You may think, well, it's a coin. Bad character, good character. It's the exact same thing, but it's simply not. And it has to do with the difference between action and inaction. I mean, you can think about it yourself, but I mean, the truth is that the proof that someone has done something on multiple occasions is more likely to indicate that they would do it again than the converse, which is the fact that they've never done something is more likely to prove that they didn't do it on this occasion, simply because there's always a first time for everybody. So as a result, everybody benefits from clean character at birth, right? I mean, not my kids, they were holy terrors, but you get the idea, like everyone has good character. So the courts believe, and I think correctly, that good character evidence has less probative value as a matter of fact than bad character evidence. It's just the way it is. Like, there's a lot of case law talking about sexual offending, for example, and it's like, well, sexual offending occurs behind closed doors, and you can have a model citizen who's perfect in every single way, but they're, molesting someone behind closed doors. Like, it doesn't matter that they're upstanding and they pay their taxes and they're community leaders. Look how many community leaders have been brought down by that type of crime. So good character evidence only goes so far, and that is important for limiting how much of it you can induce. So let's look at the rules. Number 1, in civil cases, they've just pretty much banned good character evidence. You just can't do it because it doesn't show enough to show that you're the type of guy who wouldn't do something. 2, we're not going to allow much of it. Unlike bad character evidence, where we'll actually prove it because it's important, you can't call evidence to support. It is not important enough. So the accused can get up and they are allowed to testify to good things they've done. I volunteer at the church. I'm a stand-up amazing person. I can do X, Y, Z, and whatever. But you can't call any evidence. It's too time consuming. It is not worthy of our time. What you can do is called good reputation evidence. That's all you're allowed to do. And witnesses can come in and they can say, yeah, I agree. So, for example, if I'm charged with fraud and I say, I'm an honest person, I would never do that, I can call evidence of people in the legal community to say, well, Mr. Sankoff has a reputation of the highest character, but they can't testify about why. They're allowed to just say, that's our opinion. And I can line up some witnesses and they can all come in and say that. Here's the downside. Once I've opened the door, as they call it, the Crown's allowed to rebut with bad character evidence. So, I mean, you remember all the rules of character evidence? You can't admit it unless it's similar, unless it has high probative value. So, again, if Johnny adduces that evidence and says, I'm a good guy, I would never do this, Well, I mean, the extent to which that's admissible, like, changes the calculus. Remember, I said probative value and relevance can be altered by what happens at trial. So let's say you have some evidence of Johnny beating lots of people up. Judge looks at it. Is it directly relevant? No. Is it similar enough? No. It's a totally different situation. He was drunk in one of these. It's just different, right? Well, then Johnny gets up and says, I've never beaten up anyone in my life. Well, is it fair to say that it would be unfair to protect him from all the other beatings that he's done? Yeah. So the rules of rebutting is that if the accused opens the door to good character, then the Crown can rebut it with bad character evidence. And I would just point out what I already said. Some crimes, the utility is better than others. If it's, say, an honesty crime and you've got a lot of evidence of honesty, maybe. But, like, as I've said, you're allowed to admit it. The courts find it has very limited utility, so use it with care. Just a couple of things to point out. Guess what opens the door to good character? Bad character. If you attack the co-accused, like, your character's in play. There's no doubt. You have opened the door. If you accuse the accused, because what you're trying to show is, think about what you're doing. Remember I said you can attack the co-accused? Yes, you can. If you're trying to show that Fred is more likely to have done this and it wasn't you, right? And I had nothing to do with it. Well, like, you've now said, I'm a good guy. He's the bad guy. That's what you're indirectly saying. He's the worst guy. Well, your character is in play once that happens. There are other ways to do it, but lots of other ways. But let's assume for the moment you've put your character in play. What can they do in reply? Again, because of the rules on bad character evidence, putting your good character in play doesn't just open the floodgates and the Crown can do everything they want. No. They can first of all cross-examine you on the character trait. So if I say I never beat people up, they can't, like, adduce good character evidence to show that I have a child porn collection. Sorry, bad example. But you get the idea. That, it's Johnny, by the way, not me, of course. Like, that is the issue that cannot be crossed on. You're only crossing on violent offending, so, like, you can cross fully on that. Show any aspect of why that should not be believed. 2, if they call good reputation evidence, the Crown is allowed to call rebuttal reputation evidence, but only if reputation evidence was claimed. 3, you can call testimony that rebuts, specific testimony that rebuts the good character claim. So again, like, if you have evidence that rebuts, he says, I've never beaten somebody up, you can call someone that says he has. That is rebuttable. So, I mean, there are a lot of issues here, but if he says that, right, like, again, admissible as part of the Crown's case? No. But admissible in reply? Yes. Like, that is what this is. You can call testimony to show that. Finally, I want to talk about Section 666 of the Criminal Code. This is a bit of a strange one. And again, I want to stress that the testimony that rebuts has to rebut the character trait. Opening the door to character doesn't allow the Crown to just go a full season go, right? Except for convictions. If the accused adduces evidence of any good character trait, if you have a prior record, that's coming in. It's just coming in, and they can adduce evidence of the previous conviction. I have a few issues about this, but nonetheless, that is the way it works. I personally think Section 666 is a bit too broad, and I think that if they adduce a specific character trait, you should only be allowed to rebut with that character trait, not everything they've ever done. But the case law and the statute are against me. So, if he's charged with assault, can they adduce a prior conviction of rape? Let me stress, whether they'd get the rape in the other case is debatable. It depends what Johnny said. If Johnny said, I never punched someone out in a bar, I'm not convinced this rebuts that character trait, but it might. I mean, it's a violent offense, so, like, that would be up for the judge. But if it's a conviction, it's in. You don't even have to call the witness, just adduce the conviction. And fraud, like, I personally think this is ridiculous. I don't see why, if Johnny says I never beat people up, you can start adducing his convictions of fraud. But that is what the law allows. So until someone challenges it constitutionally, which I'd love to do, that is unfortunately what the law is. Yeah, so that was a lot, and I know it. But as always, let me say I hope this was of interest to you. Have a great day, everyone.